Good morning, everybody. I'm Kevin Conroy. I'm a partner in the law firm of Foley, Hoag & Boston, otherwise known as Titletown, USA. I don't know if you were up late last night, but apparently you can, people from New York, apparently you can play hockey in late May with the Bruins up 3-0. So please keep that in mind. And a couple of announcements before we get started. First, global disclaimer. We've got some great panelists today who are going to talk about wonderful things. What they're saying today, they are saying in their own individual capacity, and they're not necessarily speaking on behalf of the agency. There is going to be time for audience questions today. So I want you thinking about that. You probably were not up late last night watching the Bruins. I want you thinking about your questions. Get ready for them. It's going to turn to you, and we're going to have some good back and forth today. So I'm going to first turn to each of the panelists to talk a little bit about themselves. First, I've gone through the program a couple of times, and they are some very distinguished speakers here today. I think we're going to hear from somebody later who's climbed Mount Everest. We heard yesterday from the former head of the Cfpb. But I think there's only one person in this whole group who is speaking on two different panels, and that is Sandy. So Sandy, why don't you introduce yourself and talk a little bit about who you are?
Okay, my name is Sandy Brown. I'm an assistant director within the Division of Financial Practices, which is inside the Bureau of Consumer Protection at the Federal Trade Commission. Just to give you a quick primer on the FTC, we're an independent agency headed by 5 bipartisan commissioners. And it was actually just in the last year that we got an entirely new slate of commissioners and also a new director of the Bureau of Consumer Protection, who I understand you'll be hearing from later today. So in terms of what we do, we are primarily a civil law enforcement agency. So that means the bulk of our efforts are spent investigating and potentially pursuing legal action where companies or individuals might be on the wrong side of the law. In terms of which laws, our bread and butter statute is the Federal Trade Commission Act. It prohibits unfair or deceptive practices. It also gives us fairly broad jurisdiction. We sort of cover the waterfront in terms of commercial sectors. A notable exception, perhaps for this audience, is that we don't have jurisdiction over banks, but we do have jurisdiction over bank subsidiaries and all non-bank financial service providers. Beyond the FTC Act, we also enforce sort of other key consumer financial protection statutes, Truth in Lending Act, the Equal Credit Opportunity Act, the Fair Credit Reporting Act, Equal Funds Transfer Act. So we do quite a bit of consumer protection work in the space. Thank you for having me here.
Thank you. I mean, you're in a relatively new role. Why don't you talk about that and your background?
Sure. So I'm Jaime Werke. I head up FINRA's newly formed Office of Innovation. Background on FINRA, we primarily regulate the U.S. broker-dealer market as well as other areas of the securities industry. I've spent about a little over 3 years now at FINRA. I was at the SEC prior to that and worked for a number of years in the law firm for that as well.
Paul?
Paul Watkins, and I run the Office of Innovation at the CFPB. I was up late enough last night to see the Red Sox lose an extra innings.
Fair enough.
Thank you for having us here on this beautiful day. I assume the weather is always like this. This is a spectacular view for a conference. The Office of Innovation at the CFPB, you all I think heard a lot about the CFPB yesterday. You had the former director speaking to you. The Office of Innovation was created in July pursuant to the purposes of the Bureau under Dodd-Frank. Those include ensuring that markets are fair, transparent, competitive, and that consumers have access to those markets. And when you think about how to achieve those goals, rules and enforcement and typical regulatory activities certainly play a role. But another role is played by folks like the company you just heard from before our panel, because we can't mandate that a bank give people a higher interest rate on their savings. We can't do that. We depend on innovation and competition to derive those positive dynamics that consumers can experience so that they can have a holistic experience of consumer protection, not just enforcement and rules, preventing the downside, but competition and innovation driving the upside and providing them the opportunity to access better products. That's why our office exists.
That's great. So, Paul and Jaime, you're both responsible for innovation at your agencies. Sandy, I'm going to let you talk about innovation as well, because I know that's important to your agency. But you know, this relatively new phenomenon of having specific people responsible for innovation in the agency. Can you talk about that? Talk about some of the specific areas you're trying to bring innovation to in what your agencies do?
So, happy to start. So, let's draw the analogy. A friend of mine got my wife and I this anniversary gift that was basically like an adventure trip in West Virginia where we did whitewater rafting and zip lining, a couple other things. My reaction was, yeah, this is going to be really, really exciting. I want to do this. And my wife's reaction is, well, what kind of grade rapids are they? How high are we going to be climbing? And I think that excitement level for innovation also mirrored with the need to kind of think about what the potential consequences are is really part of what our group is really designed to do. There's a lot of parts of innovation that's really potentially beneficial to the investors. And I think it's important upon regulators to think through that and try to promote those benefits where possible, but also to understand there's potentially new risks that are being introduced through innovation that may be taking away old risks, but need to think through how that affects the market and what the implications of that are.
For us specifically, it ties back to the statute. It ties back to our 4 purposes. Those are to ensure that certain characteristics are present in the market for consumer financial services. Fairness, transparency, competition, and access. Prior answer, I touched a little bit on competition and access. But innovation is also potentially driving fairness and transparency when you look at underwriting criteria and the way that technology has lowered the cost of individualized underwriting. That potentially creates positive incentives for judging people based on their individual risk, as opposed to judging them based on criteria that we would agree is unfair, such as their membership in a protected class. So we're looking at how innovation can accomplish these purposes of the Bureau, while at the same time, as was mentioned before, watching the risks that may arise from new products. We think that the overall trend is very positive. There are certainly risks along the way. So we've proposed a number of policies to accelerate what we view as the positive aspects of innovation.
Do you want to talk about a couple of those policies, and then I'll turn to Sandy?
Sure. So in December, we proposed revising our no action letter policy and then adopting a sandbox at the federal level, which would be, in its breadth, would be unique among federal agencies. We previously proposed revising a trial disclosure sandbox. So 2 sandboxes, 1 no action letter program. The main difference is that a sandbox provides a safe harbor. So if someone is testing a product where there's some regulatory uncertainty, the way our program works is we provide a safe harbor. So they're giving something up. They're agreeing to test this product for a limited period of time. They're agreeing to allow us to review the product. They're potentially agreeing to allow us to monitor the product. In exchange, we're giving them protection from being sued by our Bureau and potentially others. And what this does is it allows us, first of all, to learn about innovation on the front end. It requires us to learn and understand these products before something goes wrong, so that education is not happening solely through enforcement actions. And it also provides an opportunity for companies that are very concerned about their regulatory compliance to innovate. We do not want a market where it's only the companies with nothing to lose, right? No brand, no ongoing relationship with infrastructure who feel like they have the ability to innovate. We want companies who expect to have a long-term relationship with regulators to also be able to innovate, And so that's why, one of the reasons why we think it's important to have formal structures for that to happen.
So do you want to talk about innovation in the FTC?
Yeah, sure. So we don't have an Office of Innovation per se, but we are very supportive of innovation. Just like anybody else, we too are consumers. So we're excited for products that are going to improve efficiency, give consumers greater access, lower costs potentially. So our approach is with that in mind, when we think about how we investigate or bring enforcement actions, we want to make sure that we're protecting consumers, but in a way that doesn't harm sort of pro-consumer innovations. And I can give you sort of a couple examples of cases where I think that's highlighted. So one important way in which we as a sort of policing agency help promote innovation is to make sure that the streams of commerce remain as clean as possible. That's to the benefit of all of you who are playing by the rules and to the benefit of consumers. So, for example, in recent months, we've brought a couple cases in sort of the emerging technology space. So there was a scam that was targeting consumers' interest in cryptocurrencies. Late last year, we brought a case, it was called the Bitcoin funding team case. They basically tried to piggyback on widespread consumer interest in Bitcoin to essentially run a business sort of operations scam. So we pursued them in federal court. And actually just last week, we announced a crowdfunding case where the creator of the crowdfunding project was marketing something called the iBackpack. It sounds great. In fact, probably similar products are already on the market, but it promised to have a backpack that incorporated batteries and all the cables you would need to wire your devices. Also had like Bluetooth speakers incorporated. All great. Raised about $800,000 from consumers. At the end of the day, unfortunately, not a lot of that $800,000 went into making that product. And so we pursued that company actually in federal court. And I'm actually going to read a quote that our Bureau Director, Andrew Smith, in announcing the case, made about that case. Quote, "If you raise money by crowdfunding, you don't have to guarantee that your idea will work, but you do have to use the money to work on your idea, or you can expect to hear from the FTC." I think that's a helpful way to frame how we approach our work. We recognize, using crowdfunding as an example, that consumer expectation in the crowdfunding space is not the same as when they walk into Target and want to buy a product. So it's not that you have to guarantee that the product that you're selling on Kickstarter is going to pan out, because part of what you're doing is kickstarting an idea and there's some uncertainty there. But the underlying basic principle that when you are crowdfunding in support of a project, that you should be using the money for that project, that we had no qualms about pursuing legally. So at the end of the day, we hope that our role in supporting innovation is to help increase consumer trust and confidence in the products that are being innovated.
Jaime, could you talk a little bit about FINRA's recent publications and how they fit into the larger goals of the agency?
Sure. So, prior to kind of even developing the Office of Innovation, we had what was known as the Innovation Outreach Initiative that we started about a year and a half ago, where we actually went to the industry through developing a FinTech industry committee that consists of our member firms as well as academics and some investor advocates, through developing a series of roundtables. We had one in San Francisco, in New York, and Dallas, and doing several number of FinTech office hours, where we try to get an idea of what issues around FinTech that folks were concerned about, what the pain points people were seeing, and try to kind of build that into our knowledge base. And kind of part of that led to the development of various investor alerts as well as white papers. So recently in the past year, we had a couple investor alerts that went out working with our investor education group that talked about social media sentiment investing. And for those of you that may not be familiar with it, it's basically the idea of using social media information, trends, or data points in order to help with your investment decisions. And hedge funds and other private funds have been using that type of information to kind of gain alpha on the market. But we'd also recently seen it kind of spill over to the retail space. So the investor alert talks about kind of some of the cautionary things investors think about before using kind of that type of information, and to make sure it's not the only source of information that they're using when they're trying to make investment decisions. Another related publications that we've had a series of publications related to digital assets and some of the implications of that. We also put out white papers on issues around digital investment advice, probably more colloquially known as robo-advisors. as well as blockchain technology, where we talk about the uses in the securities industry and what some of the regulatory implication of those uses were as well. And most recently, we put out a paper on RegTech.
Wow, that's a lot.
Yeah.
Paul, I wanted to go back to the sandboxes for a second because, I think even for lawyers, for people in compliance, sandboxes are a great idea. I think the challenge is that some of us are having trouble getting our arms around it. And is there a real practical example that you can get? I know you worked on sandboxes also in Arizona, and is there a real practical example that you can give so that people can kind of get their arms around how sandboxes work and how they can be helpful to industry?
Absolutely. So before the Office of Innovation, the Bureau had existing policies. We had a trial disclosure policy, we had a no action letter policy. The problem was that they were very, very challenging to use. So we issued one no action letter, and it has elements that are similar to a sandbox, so I can talk maybe about that example to illustrate how things might work going forward, assuming the policies are finalized. So we issued a no action letter, the prior administration did, to a company called Upstart, which uses educational data as part of its underwriting for loans. And so, of course, when you're looking at sources of alternative data, even if your algorithm is correct, what you're worried about is that you're importing some sort of discrimination through your input, so that even if your algorithm is fine, because there's a problem with your input, then your output may have some kind of discriminatory impact. So this is an area where it's sort of undecided. It could be that when you bring in new categories of alternative data, that credit risk is more accurate, that access to credit is expanded. It could also be that you're correlating with discriminatory characteristics, and it's really hard to know which one of these will be true until you see how the product performs. So what the Bureau did was provide a no action letter to Upstart so that they could use this educational data and then provide reports to the Bureau on how this product was performing. Now, we haven't publicly released these reports. We're in the process of summarizing this. I can tell you that this is a positive experience that we're looking to build off of. But that's the sort of example where a sandbox would be appropriate. Now, some of the issues with that, and the reason why I think nobody else applied it, it took 2 years to get that letter. They spent hundreds of thousands of dollars. I don't know if they spent 7 figures, but it was extremely expensive for them to get that letter. They also did not receive any sort of safe harbor. So while they haven't been sued, they didn't get any assurance that they wouldn't be sued. So what we're looking to do is replicate the success of that example while also improving the process so that it can be used more often going forward, because we think that that type of process is actually a responsible and measured way to bring innovation into the market. Of course, nobody has to use these policies. We're not a licensing entity. Nobody has to come talk to us before they launch a product. If we have a problem with it, we will very likely come talk to you. But nobody has to talk to us on the front. This is a voluntary system that's being set up to facilitate innovation and compliance.
Thank you for that. That was useful. Can one of you talk about efforts in artificial intelligence? I know there's a fair amount going on. I know some of your agencies are considering and looking at it. Could one of you talk about that?
Sure. So last year, towards the fall of last year, we put out a special notice on innovation where we asked broadly issues around innovations and what our role as a regulator should be in the context of promoting innovation that's consistent with investor protection and market integrity. And one of the areas we heard back on was artificial intelligence. And as a result of some comments we received, this year we're really looking to take a very deep dive into artificial intelligence. Specifically, we're going to look at issues around kind of, what types of artificial intelligence are being used. Because artificial intelligence is really very much an umbrella term. There's things like deep learning, machine learning, which is probably more widely used, natural language processing, depending on who you listen to, robotic automation. So it runs a whole gamut of various types of technology techniques that are being used in the context of artificial intelligence. In addition to that, try to look at kind of where within the securities industry is it being used. You know, there's examples within the front end where it's customer interfacing, things like robo-advisors or other types of tools are kind of being used in the front end. And also kind of in the trading side, whether it be through algorithms, portfolio management, or other things like that. And on the back end, and things like compliance and operations. So kind of look at the gamut of kind of where it's being used. And finally, think about kind of what are the practical considerations, potentially from an operational standpoint, and what type of regulatory issues may be implicated. And kind of, you know, do that in conjunction with working with the industry, trying to understand from them what they're seeing and kind of what they're actually using.
Well, go ahead, Steve.
Yeah, so in terms of AI, we've done a little bit of work. We had a series of fintech forums that spanned 2016 and 2017. One of them specifically addressed blockchain and AI. And the goal of that forum was to sort of understand kind of like what was going on the cusp of AI and AI's integration into, you know, various products and services and tools. You know, I would say in terms of resources, if you want to think about, you know, how you're integrating AI in a way that's sort of consumer protective, we had a big data report that came out a few years ago that kind of gave some very high-level rules of the road. I don't know that I'm going to say anything groundbreaking here, but you know, if you're thinking about using AI in a way that like amasses large data sets and you're going to be engaged in decision making based on those data sets, I'd suggest kind of make sure that that data is accurate and unbiased. You also want to think about, to the extent AI provides very valuable shortcuts, but then you don't want a shortcut, or is compliance with consumer protection laws. So, you know, a couple examples, particularly in the credit decision-making context, Fair Credit Reporting Act, the Equal Credit Opportunity Act, both of them have very specific requirements to the extent credit decisions are being made and the need to communicate with consumers about adverse actions. So that's another thing to keep in mind. And then, of course, generally, to the extent you are marketing your AI-based tools, you know, perhaps obvious, but I think worth saying, you want to make sure that any claims that you make about your use of AI are truthful, non-deceptive, and of course, to the extent you are using that data in ways that might not be foreseeable, potentially harmful to consumers, you want to think about that as well and try to avert any of that harm.
We're also looking at AI in a number of different contexts. One of those is internally, we assimilate a large number of complaints. So we're looking at solutions to analyze those complaints more effectively. And externally, we're tracking developments in the market, which I assume many of you are very aware of. There are AI applications for use in credit underwriting. I think there's a lot of potential there. Standard issues that are discussed regard explainability, how that interacts with adverse action notices under FICRA and COA. Also, with respect to fraud monitoring, there are, in some respects, that could intersect with our jurisdiction around preventing discrimination. So that's an issue that we're looking at to understand, because that seems to very clearly be the future that for fraud monitoring.
Sandy, Paul, you know, I think one of the things that frustrates industry at times is that there feels to be a wide variety of different actors who are trying to enforce consumer protection issues, right? We heard yesterday from the state AGs, we talked about their concerns in enforcement in consumer protection. Obviously, all three of your agencies have roles in consumer protection. You know, and I know I've worked with clients that are getting notifications, getting requests for information from various state agencies for the same practices. You know, do you work together? How do you ensure that you're all not investigating the same company? How does that work?
I'll take the first go at this one. Particularly with respect to the FTC and the CFPB, we have areas of overlapping jurisdiction, obviously, but there are sort of specific, fairly rigorous practices in place to make sure that we are not duplicative in our work, that we're not overburdening business, no one wants that, and that we're relatively consistent in terms of what you guys can expect from us. And we do that in a few different ways. In fact, since 2012, the Federal Trade Commission and the CFPB have had a standing MOU to specifically address how we, on an ongoing basis, do coordinate. And I can tell you that that happens. I'm in the division that does a lot of that coordination. We coordinate, but at a high level, we have a database where we know what each other is working on, so that there is no danger of us accidentally investigating a case simultaneously. And our staffs have now in the years since that's been implemented, I think, it's become fairly regimented that we know to make sure that that's not happening. And then in terms of ongoing coordination about the type of work that we're doing, we do that both at a management level and at a staff level. We have working groups focused on sort of specific areas or practices, so that again we're in the loop on each other's work.
And are the state AGs sort of in that same collaborative effort?
So there's a specific MOU between CFPB and the FTC because of so much jurisdiction, but there are actually a number of working groups that we participated on with state AGs, and certainly like in the education space, for example, I can speak personally, over the years there have been a number of state AG working groups that we're all a part of, and again, the idea is to make sure that we understand where each other is, that we're not being burdensome, and that we're using resources efficiently. And then in terms of other, for the FTC, we sort of have we have a piece of a little bit of everything, and so we do consider it our responsibility, and we do informally coordinate with as many agencies as we need to make sure that we have, a clear understanding of what the regulatory landscape looks like. So we coordinate with the FDIC, OCC, Treasury, the Fed. So we try, and I think we're relatively successful, but maybe you guys will have complaints and questions about that. I don't know.
Paul, do you want to talk about that?
Sure. So I saw this from one perspective when I was in the Arizona AG's office, which I know is similar to your perspective. And then now at a federal regulator, this is a unique aspect of running a business in the United States, to have 50 AGs, 50 banking commissioners, at least probably 9 or 10 federal regulators touching on this space. We do try to coordinate, as been mentioned. We're talking behind the scenes, but at the same time, we often hear that different regulators are approaching companies with different perspectives because so much of the compliance mandate is particularized. I'm sometimes over in Europe. I was over in the UK recently, and it's interesting that it sort of doesn't fit with my general conception of doing business in America. That it's interesting to talk to a European company about when they're thinking about expanding to the US. They're terrified of our regulatory structure. Often they don't even know where to start, which is just a little bit different picture than if I were in a completely different field. That probably would not be my first impression that a European company would have upon moving to the US.
Right. I mean, what regulators do you work with?
So we work with a number of regulators, both on a bilateral basis and a multilateral basis. As you can imagine, probably our closest relationship is with the SEC, and my group in particular works very closely with folks like Ballard Panic and the FinTech group with the SEC on issues related to innovation. More broadly in FINRA, we obviously work, again, very closely with the SEC. In addition to that, though, we also work with a number of other regulators. We have regular meetings with international regulators such as ESMA, the UK FCA, as well as domestically with folks like the CFTC and others. In addition, we work, especially in discrete issues, on various forums on a multilateral basis. For example, we look to set up a regulators forum on digital assets, in which we invited participants from the Fed, the SEC, the CFTC, the New York AG office, NASA, CFPB as well, a number of other regulators to talk about issues around digital assets, and both on terms of kind of what we're seeing and what what we saw as the pain points to make sure we kind of had an understanding of what other jurisdictions, of what other regulators are looking at. And then also, through IOSCO, we work on a number of forums, including there's a FinTech forum and digital asset forum that we talk with regulators, again, both domestically and internationally, related to these issues.
So I know one of the frustrations that industry often has, especially if they're under investigation, is that they feel like the people they are dealing with at an agency are out to get them. And I'm sure none of you are out to get anybody, but you may have colleagues who are giving off that impression. Do you have in your agencies sort of an ombudsman or somebody like that who somebody can, if they feel like they're being mistreated by an agency in an enforcement context, somebody to go to? Is there, do you have examples of that? I know when we were in the Massachusetts Attorney, I was in the Massachusetts Attorney General's office, we appointed an ombudsman, and that was sort of a little bit of a safe space, or a little bit of a place where somebody could go to at least air their grievances if they had an issue.
We do have an ombudsman who does interact with external stakeholders. As far as somebody interacting with the ombudsman in that way, I guess that's a fascinating question. I haven't been asked before, and I don't think I
should have told you I was going to ask.
I apologize. I'll try to have a better answer for you next time.
We don't have an ombudsman per se, but we do have a really active division of consumer and business education that has a pretty prominent presence on social media and often ends up being like the first portal for people to reach out. Now, they don't necessarily serve an explicit role you're describing, but we have a number of channels, I think, that are available to people to kind of make their voices heard and to put issues on our radar, and we do take all of that seriously.
Yeah, in FINRA we do have a formal ombudsman's office, and we have an ombudsman. But I would say that, even before it gets to that level, I think part of the reason for developing the Office of Innovation and other kind of outreach efforts that FINRA has done through FINRA 360 is to the extent that, obviously, our main mission is investor protection and market integrity, right? So, but to the extent people have legitimate things that they're trying to get resolved with us, even before it gets to be an issue, I think, working through, if it's related to technology-related issues or innovation-related issues, working through groups like ours, talking with others within FINRA to hopefully resolve those issues, I think is probably a good starting point so they don't even really become issues. And I think that's what we're trying to do, to the extent that there's good market participants, they're trying to do the right thing, work with them in that endeavor.
I'm going to ask one more question, and so this is your chance to give it your one final thought to all the questions you're about to ask. So, you don't have to listen to the answer while you think about your question. If each of you could go and talk just a little bit about the hottest or the enforcement priority or the biggest priority that either you're working on or somebody in your agency is working on that's a little bit more new than some of the other stuff you've done. Is one example, maybe you could talk about it for 30 seconds or so. You want to start, Sandy?
Sure. Well, if you wanted an extended riff, I would have talked about marketplace lending, lead generation, and small business financing. But to keep it to the 30 seconds, I guess I would choose small business financing is the area that's sort of newest for us on the horizon. We actually just hosted a workshop last week on small business financing. There are a lot of new, some of them fintech-oriented products aimed at giving small businesses access to credit, capital, but there's a lot of confusion on the consumer side. And we heard, I think, a really interesting discussion about sort of the gaps in legal protection for small businesses looking for financing. Things like TILA don't readily apply. And so, but the FTC Act, General UDAP, unfair and deceptive practices, are a baseline prohibition. And so that is something that's been of interest to a number of our commissioners and our bureau director, again, who will likely be talking about that later as well. And so we are taking a pretty close look at that marketplace, and I expect there will be more to come.
And I think you know this, that small business lending was also a hot topic yesterday at the AG conference.
Right.
And so, the AG panel yesterday. Interesting that you bring that up. Go ahead, Ivy.
So we already talked about one of them. I think one of the things we're really looking to work on this year is artificial intelligence. So I won't hit on that again. But another area that we're looking to get a little bit more involved in is around machine-readable rulebooks. And this is also another topic that we talked about in our special notice. We received a lot of feedback about how, and for those of you that may not be familiar with it, it's basically the idea that you embed a taxonomy to put intelligence to figure out kind of what the rule relates to. For example, if something says you have to maintain information for a period of 5 years, you can tag it record keeping. And if a firm has their own compliance policy or procedures, tag record keeping. As those things are updated, you could have the machines kind of talking with each other to let them know in an automated way what they need to update. So that's an area that we're looking at to see if that's something that we could do within FINRA, and we're actively looking at that right now.
A big initiative for us has been the coordination point that you touched on earlier. We joined a network called Global Financial Innovation Network that's led by the FCA, Financial Conduct Authority out of the UK, regulators all around the globe, working together for cross-border trials and to develop RegTech solutions together, learning from each other, and also where we can, working together. In each of our policies, we've highlighted the need for coordination with state and other regulators, because I think that's going to be essential with any sort of testing going forward. So that sort of coordination and clarity, I think, will continue to be a big focus for us.
Okay, it's your chance. Who's got a question? I think there's microphone's going to come around.
Hi. I'm wondering, there's been a lot of talk for many years now about whether technology firms need to be regulated rather than just the financial institutions that they are supporting. And a couple of weeks ago, there was a case that ended in a hung jury. US v. Jitesh Thakkar, his company wrote software that was used by the big spoofer in the UK. And it raises that question about where you draw the line exactly. So I'm wondering if you could share your thoughts on where you draw the line exactly and how you see that evolving, or do you see that changing at all in the current environment?
Somebody want to take that?
I would just say we do see a number of these issues through looking at vendors that are contracting with regulated entities. That's similar for us, and also obviously the prudential regulators. So I would say right now that's our focus and our engagement with the pure tech firms.
From the FTC's perspective, I think we take a fairly broad scope because we are mandated to by Congress. We have to sort of police for unfair and deceptive practices across commercial sectors, like I mentioned. So we don't necessarily restrain ourselves, but we do have to be fairly sort of careful and selective when we choose to engage in sort of investigations and enforcement. So we try to prioritize where we see the greatest degree of harm or complaints or areas that have been left unaddressed. So I don't know if that quite answers your question, but that's our perspective. Mm-hmm.
Yeah, in FINRA, the entities we primarily regulate are ones that are registered member firms with us. So to the extent that they are, kind of their activities would fall under our regulatory preview. And in that context, I would say it's probably answer similar to Paul's, to the extent that they're working with outside vendors in order to incorporate that technology within their systems. We put out a notice to members around outsourcing, and we actually talked a little bit about this again in our special notice, where it's important to make sure you have an understanding. You can't just throw it off to the vendor and say, you guys do it, and we're not going to touch it, we're not going to worry about it. You have to make sure you have an understanding of what you're bringing on into the system, and within the context of the regulated entity.
Sir, go ahead.
Hi. This question is for Paul. That's your name, right?
That's my
So,
first part of the question, right?
You got it right.
Was that your question?
I have another.
You got another one?
Yeah. So
Okay.
I kind of asked this question to Rich Cordray yesterday, but as the CFPB is working to figure out how to, regulate these innovative companies that are breaking the mold of traditional banking or financial services. what are your thoughts on the Office of Innovation, innovating with technology to help you wrap your arms around these companies and these sandboxes, you know, providing you with, like, for these companies, like, with a consistent process. It's simple to, you know, monitor what they're doing.
So thank you for asking that question. I think this has been something that the Bureau has thought about for a long time, which is how can we take advantage of the technology that's being used by industry for compliance? Can we interact with that in an efficient way so that there are savings that hopefully you all pass on to the consumer, but also efficiencies in spotting fraud and things that go wrong. The one step that was taken was with HMDA data. So we built an API to facilitate the uptake of that. We used to, receive these giant faxes of mortgage originations. And sometimes there would be a sophisticated entity that had a very well-run compliance program, and then sometimes, faxes, handwritten stuff, and then we try to put all this stuff together. And I think it was frustrating for everybody involved. So hopefully the scenario that we've come up with is an improvement. But I would say this is a great opportunity to comment on, take a look at our rulemaking agenda. Anytime there's a notice and comment period, if you have an idea on how to facilitate the uptake of information that's required in a lot of these rulemakings, I think that is a very productive thing for industry to engage on and comment on.
Any more questions? Well, we are at, oh, sorry, there's one in the back. Yeah, go ahead. We're not out of time. You got one more question, but this is the last one.
I just, Sandy in particular, I just met somebody from the FTC you might know, Melanie.
Yes, she's my boss.
I know. So she mentioned
Whatever
lead
she
gen.
said, that's the answer.
She's exactly right. She mentioned lead gen, you mentioned lead gen.
Yeah.
What in particular is the focus on lead gen? I know the FTC Act covers the UDAP issues, but is there a particular issue you guys are focusing in on?
So it's not so much issue specific. I would say in the context of lead generation, what we want for advertisers and everybody in the ecosystem to be focused on is that you can't create shields to liability based on where you are in the pipeline. Lead generation can be a complex ecosystem, and perhaps necessarily so, but the FTC is not looking purely at the first party who is directly engaging with the consumer, i.e. the publisher or the affiliate. What you can't do is essentially pass off liability by having a third party between you and the consumer. So if you're the advertiser, if you're the network, you too have responsibility for making sure your practices are not unfair or deceptive, and that you are vetting and monitoring your upstream lead generators who are engaging with consumers. It's not sufficient, perhaps, to just retain sort of a third party, compliance program or monitor and just treat it as set it and forget it. You should be sort of engage the process by which that entity is doing monitoring or compliance review on your behalf should be meaningful. To the extent complaints or issues, problematic practice are being flagged for you as an advertiser, you need to respond. So that's kind of the high level message when we're talking about lead generation, and I will say that's another area that is of particular interest both to our Bureau Director and our commissioners.
Thank you, Sandy. Thank you, Jaime. Thank you, Paul. This was a great panel. We appreciate it. Thank you.